My Lords, I'm grateful to all those supporting Amendment 75, and I'm grateful for the speeches under that amendment. I'm further grateful to the Noble Lord Kerr and the Noble Lady Baroness Chakrabarti and the Noble Lord Alton, all of them helping us to delve deeper into the issues, both legal and moral, in these amendments. I'm particularly grateful for the noble and learned lady Butler Sloss, who has set out her amendments 70, 73 and 85, to which I have subscribed my name. This is an issue which is close to my heart, as I speak on behalf of the Church of England on human trafficking and modern slavery issues. I do so from the city of Bristol, with its history of slavery and its current commitment both to prevent human trafficking and slavery, including domestically, so we train our lay officers to spot the signs of those hiding in plain sight, and also to provide refuge for those who are on their journey through the NRM. I was particularly grateful too to the Noble Lord Deepen, as I'm going to miss church downstairs, I think, and I'm grateful that he has brought church upstairs in his Ash Wednesday word to us about the deep moral issues that there are in our debate today. I am concerned by the Noble Lord Horam's response about drawing the terms of this bill very tightly, because it seems to me that the terms of the bill include those who are already victims of crime through human trafficking. Surely, and this is the nub of my argument, it is right to prevent further risks to people who have already been victims of a crime to be minimised, and we are obliged under both national and international law to do that. Hence, Amendment 70, which would mean that nobody who is thought to be a victim of modern slavery could, as we've heard, be removed to Rwanda, at least before a conclusive decision is made on their case, or without assessing what it means for their safety. Such consideration for victims is the least we can do. Since the start of 2022, over 4,000 people who arrived on small boats have entered the National Referral Mechanism for Modern Slavery. Under the current proposals, they are both suspected victims of crime and eligible for removal to Rwanda. They may well have been trafficked here against their will, as we've heard, and they're now facing further jeopardy. We need to make sure that that jeopardy is removed as far as we possibly can. The UK had until now a world-leading referral system for victims of modern slavery. It's something of which we can be rightly proud. I am concerned, as are others, that this bill, compounding other recent legislation, puts that world-leading status at risk. Not only are survivors of modern slavery victims of a terrible and traumatic crime, they will now be removed to another country altogether, re-transported to a country which will not, in all probability, treat them well, because the legislation of the treaty do not address concerns that we've heard about this morning, and the concerns of the Global Slavery Index, that the Rwanda government's approach to this issue will put those transported there at risk. Amendments 75, 73 and 85 ensure greater transparency as this legislation is implemented. The amendments mean that we would have a better understanding of the picture of modern slavery as the bill and treaty are put into effect. As currently drafted, the bill will have a potentially devastating impact on survivors of modern slavery and our nation's ability to tackle this crime. Ensuring that the implications of the bill for victims of modern slavery are subject to ongoing monitoring is the least we can do. The UK has a strong national referral mechanism, but without proper monitoring and transparency worked into this bill, we risk entrenching vulnerabilities and pushing victims back into their original abusers' hands. Modern slavery and human trafficking is a terrible crime, which represents a traumatic experience. If we are committed to tackling it, monitoring of the implications of this bill for the victims will be fundamental to an ongoing response.